Hello, this is Keith Shindler. What are we doing today? We have another session of Facebook Live. It's been a little while. Facebook had changed some of their functionality, so I had to figure out how to redo this with the new tools that Facebook provided, and we did it. So today, we're joined by Jessica Barrera. Hello, I think you guys have seen Jessica before on some of our sessions. And the purpose of these Facebook Lives is, hi Jessica, the purpose of these Facebook Lives is to bring to the Facebook community useful information that's going to help our viewers, friends of our viewers, loved ones of our viewers, recover the maximum compensation when they're injured as a result of someone's negligence. Sometimes it could also be intentional, but generally these injuries are the result of a negligent conduct. Today, we're going to talk about something that was in the news maybe a month ago. And what happened, sadly, was there was a 7-year-old girl playing on her driveway, very innocently, and she was allegedly kidnapped by a person who was driving for one of the largest parcel delivery companies in the world, and then sadly they found that little girl murdered. And so the question becomes for the family, I want justice. So they come to me and I'm going to help them claim your justice if they were to come to me. And so the question becomes, it's a criminal act of a third party, and generally the law is, and this is law hundreds of years back, an employer is not responsible for the criminal acts of one of its employees. And it could also be an independent contractor. So we're going to explore a little bit of that today. And remember, if you have any questions that we could help you with regarding serious personal injury cases, reach out to us at 847-434-3555. You could also get us on the internet at claimyourjustice.com or reach us through Facebook here. Jessica, let's go.
All right. First question, Keith. What is the theory of liability that you would assert on behalf of a client who is trying to hold an employer liable for the criminal act of one of its employees or independent contractor?
So there's several theories. One of them could be negligent hiring. One of them can be negligent training, and another could be negligent supervision. And this is all legal arguments that are designed to avoid the defenses that an employer would assert in saying, I'm not responsible. It's a criminal act.
Keith, let's break apart. And will you please first explain what negligent hiring is?
Yes. So negligent hiring, let's think that we're talking about this example, and we see that the employer hired this person or agreed to otherwise contract with this person, and they failed to do a criminal background check. And had the employer done a criminal background check, they would have seen that this particular person hypothetically had 2 prior violent felony convictions or was recently released from prison for a violent felony. And they didn't do it. And so we would argue it was negligent hiring in making that person an employee, because not that society, and myself included, we all want to give people who've served their time and have paid the time for the crimes they committed a second chance. No problem with that, but you have to balance that against the type of activity that is being performed by that person. So negligent hiring would be failing to do a background check. And if you fail to do a background check, you can't argue, hey, it wasn't foreseeable that I didn't think this person could possibly commit another violent act. Background check would have showed, hypothetically, that there were 2 prior violent felonies. And so you may have to provide a little bit more management, if you're going to hire that person, a little more management than just letting them perform the services and duties and job description the same way someone else would perform with no criminal background. So that would be negligent hiring. What's next?
Okay. Can you tell us about negligent supervision and negligent training?
Yes, so negligent supervision would be that if you have a person that you want to give a chance to, as you society should, to a person who may have a criminal background, you should supervise that person. You should do a little extra in what the employer is supervising, and it could be that you have to install a camera, in this particular case, in the car, or you have to have the person work in a team of two that would otherwise normally be only a team of one in doing the job. So you have to provide supervision to, again, if you as an employer want to avoid liability for an accusation like as serious as this, or there's many other ones, then you need to make sure you avoid you're able to protect yourself from the foreseeability argument where you say, hey, I'm representing a claim your justice, this person that was injured by a criminal act of your employee. It was foreseeable that what your employee did to my client, and you should have supervised it better. So it would be negligent supervision. What's next?
Well, Keith, this is, a very, very sad story. We feel very bad for the young girl's family. You were talking about the employee and the independent contractor. I thought you said you could only try and hold the employer responsible if the person that committed the criminal act was an employee.
Okay, so we'll answer that question, but I do want to also touch on the negligent training piece. So negligent training is another theory of liability that the attorneys that claim your justice can assert on our client's behalf to maximize their compensation for injury, for serious injuries. And the negligent training piece would be if you there's a recent case in Illinois, I think it was in the past 5 years, where a taxi driver sexually assaulted a passenger. Now, you would say, if you own the taxi company, I am so not responsible for this person's crime of sexual assault of a passenger. But the appellate court said, we don't know enough yet. It sounds long down the road, but trust me, for the victim of the sexual assault, they want to do whatever they can to hold the taxi company liable for the injuries. And now we are talking about the difference between employees and independent contractors. So another defense employers used to use regularly is, we're only responsible for employees because we provide the tools, we provide the hours, we set the place of employment, many other variables, a number of other variables. However, the law has extended to independent contractors to say, you need to make sure if you're having an independent contractor work for you, you do the same type of training, supervision, hiring checks that you would do if it's your employee. So that's not going to be an escape hatch for the employer or the person who hired the independent contractor to avoid a theory of liability for a criminal act of a third party. Good? Yep. Anything else on your list of questions you want to discuss, Jessica?
Oh, we have. And if someone comes up to us with the same scenario, would we be able to help them?
Yes, that's a good question. And that's why we keep educating the Facebook community so that the Facebook community knows, don't think you're down and out without a case. Call us. It doesn't take long for me to analyze whether there's a theory of liability to pursue. And you also don't, as a person who's injured, you don't want to wait. Call right away. So hope you've enjoyed the information and learned some of the information provided today. Remember, you can reach myself. You could reach out to Jessica at Claim Your Justice, 847-434-3555, claimyourjustice.com, or right here on Facebook. Jessica, thanks for your help today. Have a nice rest of your day.
Thank you.
And a good rest of your week for everyone out there. Bye.